I just want to sort of understand your position, and I want to narrow this to the paradigmatic social media companies, sort of news feed postings, Facebook, YouTube, Twitter/X. So suppose that that I say, just take this as a given. All right, you can argue with the facts, but don't. Suppose that I say, for the most part, all these places say we're open for business. Post whatever you like, and we'll host it. But there are exceptions to that, and clearly content-based exceptions, which the companies take seriously. So let's say they say we think that misinformation of particular kinds is extremely damaging to society. Misinformation about voting, misinformation about certain public health issues. And so, too, we think that hate speech or bullying is extremely problematic. And so we are going to enforce rules against this. If they're only going to apply to a small percentage of the things that people want to post, for the most part, they're open for business. But we are serious about those content-based restrictions, all right? So in that world, why isn't that a classic First Amendment violation for the state to come in and say we're not going to allow you to enforce those sorts of restrictions, even though, you're basically, it's like an editorial judgment. You're excluding particular kinds of speech.
Well, Your Honor, I think I take your hypo to be assuming that it's First Amendment protected activity, and I think that what you would do in that instance, you would have to run intermediate scrutiny under Turner, and the analysis regrettably.
So don't say what I take it to be First Amendment activity. I mean, do you take it to be First Amendment activity?
No, that's our whole point. I mean, again,
even though they're saying, yeah, we are a big forum for lots of messages, but not for those kinds of messages. We want to exclude those kinds of messages. Why isn't that First Amendment a First Amendment judgment?
I mean, I think the court held otherwise, I think, in Pruneyard, because there was an editorial policy against leafleting, too. And again, I don't—
No, that was just about leafleting, and the mall owner didn't have any expressive views. I'm taking as a given that these, the YouTube or Facebook or whatever, has expressive views. There are particular kinds of expression defined by content that they don't want anywhere near their site.
But I think, Your Honor, you still would have to look at the objective activity being regulated, namely censoring and deplatforming, and ask whether that expresses a message. And because they host so much content, an objective observer is not going to readily attribute any particular piece of content that appears on their site to some decision to either refrain from or to censor or deplatform.
Do you think so as to this? This is a real-world example. Twitter users one day woke up and found themselves to be X-users, and the content rules had changed, and their feeds changed, and all of a sudden they were getting a different online newspaper, so to speak, in a metaphorical sense, every morning. And a lot of Twitter users thought that was great, and a lot of Twitter users thought that was horrible, because, in fact, there were different content judgments being made that was very much affecting the speech environment that they entered every time they opened their app.
Your Honor, respectfully, that does not answer whether they have a message in their censorship, any more than, I'm sure people objected, again, quite strenuously to the fact that the law schools were permitted to interview on campus. I'm sure people wanted to ban leafleting at the mall in Pruneyard, and that does not give them a message in that. And I think the reason for that is if they are not carefully selecting the content in the newspaper, they don't have a message in the existence, in the mere existence of the content on the site.
Thank you, General.